Hi everyone, I'm sorry about that. I don't know what happened today. It seemed to be a system-wide issue. As far as I can tell, it's not fixed yet. So anyway, I wanted to finish talking a little bit about the defenses to a criminal charge. We were in the middle of talking to alibi. I'm not sure when people got cut off, but alibi is really the only way you can truly prove someone innocent. In our society, we have a not guilty or guilty distinction within our courtrooms when someone's been charged with something. And just because someone is not guilty doesn't mean that they're innocent. But if you have an alibi and you truly weren't there and you had nothing to do with it and can prove it, then you probably are considered, you should be considered innocent. So that's really the only designation where we might see someone is truly innocent. So an alibi is pretty significant and can make charges be completely dropped if somebody against someone, or not even filed against someone if they have an alibi. The next one is a justification, and this is where you have people who admit to committing an act, to committing a crime, but they claim it was necessary to avoid a greater evil. And there are a couple different types of justifications for crimes in our society. One is self-defense, and this is a huge discussion in society in terms of self-defense, what it means to engage in self-defense. And this is a defense in a situation where you could be physically harmed or killed. And if you harm someone else in that situation, then you potentially have this justification for committing a crime or harming someone else. There's lots of ins and outs of self-defense. We can talk about stand your ground laws. We will get into all of that in terms of what actually signifies a justification, but self-defense can fall under that. In the same vein, defense of others, and this is not necessarily, as I mentioned earlier in class, like a bar fight, and if you jump in with your buddies in a bar fight. Defense of others really has to be under a category where it's someone who would not be able to defend themselves, somebody who is incapable. Maybe it's someone who's older, significantly older, somebody who's significantly younger. So this defense of others really has to do with people who might be harmed should you not intervene. Again, lots of leeway in the law. Each case could be decided very differently. There could be a situation of a bar fight where you jump in to defend a friend who's involved in an altercation, and you can sort of prove that this person was incapable of defending themselves in this situation. You had to intervene and someone else got harmed. So it really depends on the particular case and how it is interpreted in that case. But nonetheless, defense of others can be a justification for committing a crime. Defense of home and property, and this is one that is always really challenging to address, and people get kind of upset about it. This is where we sort of see the castle doctrine. So defense of home and property is allowed overall, across the board in the United States, but some states, Massachusetts included, have certain exceptions about, say, someone breaks into your home, which they are committing the crime breaking into your home. Someone breaks into your home and you choose to, challenge them, to try to get them out. You are supposed to, you have this duty to retreat. In Massachusetts, we have a duty to retreat first, that your first line of defense should be to flee the home, to get out of the home. That can be philosophically challenging, that can be physically challenging. That doesn't always take into consideration that maybe you have 6 other people in the house with you. Can you all get out safely? So if it's just you, that kind of defeats the purpose. And that goes into defense of others as well. But defense of home and property is the duty to retreat. If you cannot do that, your second course of action might be to confront the intruder. And in that case, you actually will see how people have to go at someone with equal or lesser force. So if somebody breaks into your home and only has a knife and you pull out your gun and you shoot them, potentially you can be charged with maybe a second-degree murder if they die, attempted murder. So it's supposed to be equal or lesser force. Again, I know the premise is a little bit off because someone has broken into your home and is committing a crime in the first place, but there are sort of layers for this law. But defense of home and property, again, stand your ground laws, which is not valid in Massachusetts, but in many other states where we see people sort of taking action against others. So defense of home and property is certainly up for a lot of discussion. Necessity, you claim that this action was needed in order to prevent greater harm. in whatever situation it might be. Consent, justification consent was really people saying that the victim consented to the crimes. It's really hard to prove this. Sometimes you see this in rape cases or date rape cases where they believed there was consent, so no crime could have been committed, but this is a really tough justification to get pushed through. And then there's criteria for resisting unlawful arrest when police are using excessive force and the ability for individuals to fight back against that excessive force. I think overall we see that this generally does not go very well for people, but we do have this justification if someone fights back and harms an officer or law enforcement official because they had been using excessive force. Potentially this can be justified under the law, and the charges could be dismissed or used as a justification, and so you see lesser charges or not as serious a punishment for this. The next category of the defenses for a criminal charge would fall under excuses, which sounds silly to make an excuse because we want people to take responsibility. But excuses are sort of a personal circumstance that that makes the person not be held accountable potentially. So sometimes we see there's a couple different categories of excuses. Duress is probably the most popular one that we might talk about, where you see someone who has been coerced into committing a crime. We see this sometimes with drug crimes. We see this with mafia behavior. We see this where someone, maybe their family has been threatened. If they don't commit these crimes for an individual, their family will be harmed. So duress, coercion can be an excuse for committing this crime. Age, this is kind of when we talk about juveniles or that they did not understand sort of the rights or the law potentially. Age can be a tough one because juveniles generally are in their own court system anyway, but age can be a factor sometimes, depending on the case. The next one, mistake of law or fact. This will be talking about, not knowing the law. Someone say, I didn't know that was illegal. I didn't know that was against the law. That doesn't usually fly in a courtroom because we are expected as citizens of this country to understand laws, certainly the ones that potentially we are breaking. But sometimes people try to play dumb and say, I didn't know that it was against the law. So that doesn't usually go very well. The mistake of fact would be sort of mistaking the facts of a situation. This could be, again, like a rape charge or underage, where someone said they were, 18 and when they were in fact 15. And so someone could sort of say, well, I thought they were sort of legal. This statutory rape charge should not be happening. So sort of mistakes of facts of the case sometimes can happen. Involuntary intoxication. So sometimes if someone is drugged or intoxicated and they are unaware of what they are doing, that can be used as an excuse. Again, doesn't usually fly, but sometimes if people are drugged and they are unaware of circumstances of what is happening and you can sort of prove that, potentially it can happen. Provocations, sometimes this comes, we see maybe within domestic violence cases or a history of abuse that someone has gone through where they finally maybe turn on their abuser. They were provoked after years and years and years of abuse into committing this crime. And there has been more credit given over the years to this sort of provocations when you are harming someone or sort of fighting back against your abuser. Insanity pleas are really tough, and I'll talk about those in a moment. So there's a lot of different types of insanity pleas that are, again, a legal statute, not necessarily a medical statute. So there's a lot of debate, and they're not really used very often. Diminished capacity, that sometimes somebody has a significantly impaired ability to understand the wrongfulness of the behavior and to how to control that behavior. Sometimes diminished capacity can be used to sort of reduce charges or punishments. Oftentimes somebody would be sentenced to some sort of mental health facility if they were convicted of a crime, but diminished capacity really addresses people's sort of intellectual capabilities potentially. And then mental incompetence is when somebody is deemed mentally incompetent to not stand trial at all, that they couldn't possibly understand the charges against them or the system, the process that they would have to go through. And that again, often sends people to a mental health facility. Sometimes it just lets them go free, but usually there's some sort of specifications if they've committed a crime and they can't stand trial for it. So those are the categories of excuses. Again, these are all in your slideshow, so you can look at your slideshow to follow along. The last couple slides deal, I'm sorry, there's one more. I forgot the last one, which is kind of important, and certainly in this time and space that we're living in our country. These are procedural defenses, and this is actually when the whole criminal justice system, whether it's the police officers, prosecutors, anyone working for any legal team, does something wrong, violates the law, violates people's rights, individual rights, due process rights, and they should be let go because of these errors within the system. So there's a couple of categories here. Entrapment, and this is when police officers potentially create a crime or plant evidence, maybe when there wasn't one, or set someone up, entrapping them. That's an issue. Double jeopardy speaks to the fact that you can't be tried twice for the same crime. If you are found not guilty of a crime, you cannot be tried again, even if you come out and admit it after the fact, just as a legal protection under in our law system. The next one, called collateral estoppel, is actually an extension of the double jeopardy for related charges. If someone else is harmed in this scenario, you cannot actually be tried for that crime because you had been found not guilty of the first crime. So it has a sort of a relationship. Doesn't happen very often, but you will see it sometimes with these related charges. Selective prosecution really talks about a prosecutor's ability to sort of equally and fairly distribute the laws, prosecuting accordingly and not targeting certain individuals. So equal protections under the law for people, fair prosecutions and not sort of targeted prosecutions. Denial of a speedy trial falls under our 6th Amendment. We're supposed to be having our trials within 90 days, 120 days, sometimes 180 days. I think we know there are many extensions within our legal system that continues our trials potentially for years, but people are supposed to be given a speedy trial and not have this take up such a big chunk of their lives sometimes. Prosecutorial misconduct, and this really has to not going against the rights of the defendant, not adhering to them, giving prosecutors an advantage by not sharing information with the defense attorney. Everything is supposed to be made very straightforward up front. There's a whole way that the system goes to provide all of the information and evidence and just key components of the case on both sides, and it has to be shared. And so sometimes prosecutors maybe will hide things, and that becomes an issue and a violation of someone's due process under the law. So that can be a reason that they get off. And then police fraud, sort of planting evidence, police issues. Sometimes police fraud can fall under not, going through the process properly, not, filling out the forms and the reports and reading someone their rights. And if police officers are kind of sloppy in their jobs, even if someone has allegedly or actually committed a crime, they can get off because of this. So police officers and everybody within this process has to be really careful to uphold the laws and go through this sort of due process. The last slide on here talks about the insanity defenses. And insanity defenses, as I mentioned, are a legal standard. They are not a medical concept. There's no sort of formal medical process for this. Sometimes within some of these defenses, you will actually see a lot of testimony from psychiatrists, psychologists, experts in this field, or assessments that they've done of an individual. But overall, it's a legal concept. It is not used very often because it is just really hard to prove or disprove. More often than not, the responsibility for proving insanity is actually on the defendant. So they have to prove that they were not capable of understanding, or they were insane at the time of the crime, or they're insane, which is a really ambiguous term as well in general. So it's not really widespread used. There are a couple states that have actually banned the use of insanity pleas because it gives people too much of an excuse. If it is used and it is successful and someone is found guilty by reason of insanity, whatever it might be, it usually changes the sentences. It would be sort of a psychiatric institution that someone would be sentenced to for a longer period of time to have treatment. We saw this with, if anybody remembers, studying about Ronald Reagan and his attempted assassination, and the individual who was accused and convicted of attempting to kill him, spent many years in a psychiatric institution because he was deemed sort of insane at the time of that crime and had sort of lifelong mental health issues. He has recently gotten out, though. I believe he's living back with his mother, but his whole motive for committing that crime, he claims, was to impress Jodie Foster. So anyway, it's a long story, but that was kind of an interesting point where insanity was actually discussed, and it's a pretty significant case to assassinate our president, or attempted assassination of our president. So on your slideshow, you can see there's a couple different types of defenses that we hear about. One is the McNaughton rule. A lot of these are based sort of in old English code, England and Scotland, where we saw some of these standards come from. The McNaughton rule was named after an individual who sort of mistakenly killed one person when he intended to commit another. So the premise that came out of that was that if you did not know what you were doing, or if it was wrong at the time, again, this was a mistaken killing of one person when he was targeting another. So he intended to kill someone. You can be found not guilty of the crime by this McNaughton rule, this reason of insanity. The irresistible impulse says that you know what you're doing is wrong, but you still do it because you have these impulses. Sometimes we hear heat of the moment, crimes of passion. We hear for this irresistible impulse that you just couldn't contain yourself in that moment. The Durham rule talks about the person not being criminally responsible if the illegal actions were the result of sort of a mental health issue or defect. That, again, you see lots of expert testimony in there to really prove or disprove this. Substantial capacity says insanity should be defined as a lack of substantial capacity to control your behavior. So there's a little bit of the irresistible impulse in here. People can be found guilty but mentally ill at the time of the crime. You may have been mentally ill, but you still have to prove this. You know, it helps with the proving beyond a reasonable doubt, can poke holes in it. And then temporary insanity. And this, again, goes to sort of heat of the moment type crimes that you may have been insane at the time of the crime, but in general, you are very much sound mind and body. So sort of a brief overview. Insanity defenses, again, not used too much. But these are all different types of ways that we see defenses within our criminal justice system to a criminal charge. I'd say the one that we probably see in courtrooms the most tend to be the justifications or the excuses. So that is what I wanted to finish talking about today. We almost got through it all. Please let me know if you have any questions after you watch this. You do have an assignment due this week, as I mentioned, about finding a case and trying to decipher, analyze the intent in that case, the mens rea, and what type it is. So please let me know if you have any questions. Send me an email. If not, I will see you all next Tuesday. Bye-bye.